occasions, my lord. My learned friend appearing for the BTC has filed an affidavit clarifying their position as to the permissibility of inclusion of petitioner's name in the gradation list of tourist development officer. So they have filed an affidavit just now. It's a long affidavit. We have to go through it. My possibly my.
Not serve the copy. Well, they'll serve.
Today I'm finding 54, 55.
Yes.
My lord.
Maybe after the holidays, vacation.
54, 55, the request made by the council. It's the third week of July. Fourth week of July.
Fourth week.
Lordship,
Maybe
if
we'll
we
have to file an affidavit also.
The respondents may file. If the parties may complete their plea, exchange them.
Lordship,
Interim orders passed earlier will continue.
deeply obliged.
My lord, item number 20.
The side was informed or not, I am not aware of. Mr. J.I. Borbuya. Question again? Sir, please.
We only have, I will inform, today only I have five.
Lordship, item number 23, I have been informed that the petitioner has got relief. In view of that, it has
Item
become
23
infractious.
is stated by the council. This is the reporter, if any.
Item 2, 3 and 4 also become infractions.
2, 3, and 4.
Yes, sir.
3 and 4. It's interim orders, if any, and stated by the guy.
Lordship, I beg to mention item number 30, Lordship, 30. Lordship, I'm on behalf of Mr. S. Nag for all the respondents, Lordship. We have filed the affidavit, but it has not been tagged, Lordship.
Item 30, respondents have filed the affidavit. When was it filed?
Lordship, on 29th, Lordship.
On 29th. They, however, is not adequate the case report. Matter will be next week. Raise out the affidavit and adequate the case report. Have
Lordship,
you informed the council for the
yes, Lordship, I've taken consent. Lordship, can it be after 2 weeks, Lordship? Lordship, can it be after 2 weeks, Lordship?
Obliged, Lordship. May please, Your Lordship. Lordship, I'm praying to call for an affidavit filed by the respondents in item number 63 of the supplementary.
63?
Yes, Lord.
Some affidavit you have filed
Yes, Lordship, by the respondents, Lord.
today.
Yesterday, Lordship.
Respondents have filed an affidavit.
Yes, respondent number 2.
Who is
Lord.
the respondent?
I think, Lordship, Mr. Thor has filed.
You filed some affidavit in 63.
We have received one affidavit yesterday, madam.
Yes.
That is not in the record. That's why kindly call for it.
Council want the affidavit to be called on record.
Yes.
Yes.
It better relates to non-payment of pensionary.
So let it come on some other day.
Lordship, even Lordship, he is not receiving the provisional pension.
I understand. If the report be connected to the case report, we'll have it next week, Monday or Tuesday, whatever day.
Monday? Lordship,
Monday?
Tuesday will be my lord, Tuesday.
No, Monday.
Monday.
Matter item 63 is submitted that the respondents have filed their affidavit yesterday.
Yes, sir.
Yes,
Yeah. According to the history, connect the data. I think matter that is the matter.
Lordship, item number 36, with the consent of the petitioner's counsel, I beg to mention item number 36, my lord. We are praying for an adjournment. We are filing affidavit in opposition within the course of the day, my lord.
36.
36, my lord.
I'm for the petition. Let them file it here.
Item 36, council for the respondent submit that they would like to file the an affidavit is being filed in the course of the day.
My lord.
Matter therefore stands deferred. We fix it after 2 weeks.
Yes, Lord.
The day before council for the
Much obliged.
Obliged.
May I please, Your Lordship, my prayer is in respect to item number 48, seeking 2 weeks time to file the rejoinder affidavit
on behalf of
on behalf of petitioner.
petition.
Yes.
Item 48, yeah, 46. Right. Good.
May I please?
Lordship, back to item number 9, my lord. Lordship, matter may become infectious, my lord.
State that to the council that 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 the director the order dated by might be uh, taking it court. Whether the corporate it- those notices that item 9
Yes, my lord.
contempt.
Contempt, my lord.
May it please your lordship. Lordship, I beg to mention item 26, lordship. Lordship, we have to obtain some instruction from the petitioner.
Your party
For the petitioner, lordship, most likely he has retired from service, lordship. We have to obtain that instruction.
still for the petitioner MS
P. Borba.
P. Burma. 2 weeks
Lordship, after 3 weeks, lordship.
after the be listed in the month of July,
Lordship.
enabling her to obtain regarding the status of the concern.
Lordship.
Please go.
Matter accordingly be listed in the third week of July.
Deeply object.
May I please, lordship. Back to mention for distinct. Lordship,
Listing matters in court number 5.
Good morning, my lord. Good morning, my lordship. Item number 5 and 39, kindly allow me on the list of, after 1 week.
5 and 39
Yes, my lordship.
on behalf of
Aravinda does add us.
5 and 39. The request
Yes, my
of
lord.
the council stands referred to the state of the
Lordship, I beg to mention item 41 of today's daily list.
Yeah.
Herein, Lordship, the petitioners were appointed on contractual basis. Subsequently, we were sought to be replaced in 2018. And this court protected us as and when we approached. Now, Lordship, we are working and we are not being disturbed. So my friend also says that we may not be disturbed, Lordship. So
You may not.
may not be disturbed, Lordship. And we may be continued, Lordship. So it may be closed, Lordship.
Item number
Item number 41.
41. It's submitted at the bar. The council. The petitioner not be correct. According to the time, dates and with the voters, if any have been taking either
Lordship, kindly liberty may be given.
business with liberty.
Mobilize, Lordship.
May I please your lordship, I beg to mention item 24 of daily list, lordship. That WBC 218, Onil Hazarika. The grievance has already been resolved by the department, so it becomes interesting.
Mr. Peter Hartmann. Corporate. It is pending.
Highly obliged.
MS
There.
Please, Your Lordship.
Yeah.
Lordship, before I start, I would like to point out one thing, my lord. Due to an inadvertent error, I have not annexed the NIT. My lord, may grant me 1 week, my lord. Help.
the data that are coupled. To big time. Bring on report the NIT. Containing the arbitration clause.
Yes, ma'am.
It is allowed 1 week. Good enough.
Yes, my lord.
You'll bring it in within 1 week or 2 weeks.
1 week, my lord.
It's the fact.
By way of an additional affidavit.
Yes.
My lord, may
That is
fix it.
permitted to bring on report the NIT by way of an least after 1 week.
Lord, may fix the date, my lord.
For 1 week, have it on 18th? It's
Like. Please, Your Lordship. Your Lordship, matter pertains to compassionate appointment, Your Lordship, and covered with the judgment of this ordinary page of this honorable court, Your Lordship.
Yes, what do you say?
Lordship, that judgment only said that only those cases which were pending as on 3/4/2025, those cases only would be considered and placed before SLC. This case is filed much later on, Your Lord. That is not, this case is not covered, Your Lord. That
Your
notice be issued.
Your Lordship, last occasion I have mentioned, Your Lordship, on 17/5/25. It was also
Filing
17/5/25, Your Lordship, and dispose of by order dated 23/5, Your Lordship. Similar order was passed, Your Lordship. Paragraph 4, Your Lordship.
This judgment does not contain any paragraph. I mean, numbered paragraph. Which page number?
Page number 2, Your Lordship.
Page number 2. Read.
Mr. R. The Learned Addition, Senior Government Advocate, Assam, and Mr. P. Nayak, Learned Additional Advocate General Finance, Assam, have also fairly agreed to the said proposition, Your Lordship.
What proposition?
The proposition
What is
that
the proposition?
the proposition before this, Your Lordship, the application of the petitioner for a second para I am reading, Your Lordship. The application of the petitioner for appointment on compassionate ground was recommended by DLC Hailakandi. While the matter was pending before the state level committee, the commissioner and secretary to the government of Assam Personnel Department had issued the implement notification dated so and so, altogether abolishing the scheme of appointment on compassionate ground. As a result of
I
which,
think you are concerned with the last paragraph.
consensus.
You are concerned with that.
yes, sir.
Your
is
colleague is
pending
given a consensus.
Your Lordship, pending before SLC may be considered, Your Lordship, nothing.
We don't know. We pass same order and dispose it. Dispose. In terms of.
Oblige, Your Lordship.
Okay. As for number 4, we have to take step, my lord. Some time to make answer. We did not take step to have question number 4. We newly implemented.
You did not take steps.
Yeah, my lord, sir. Newly implemented respondent.
Please in all other counsel to the petitioner submits that by oversight steps on respondent taken. He prays for 3 weeks time to complete
Oblige.
process and to be listed after 4 weeks.
Oblige.
Yes.
Thank you, Lordship. Lordship, as per my instructions, Your Lordship, this matter has become incomplete. I may be allowed to withdraw it.
Counsel for the petitioner submits that the directions contained in the order dated so and so, passed in WP so and so, has been complied with.
Yes, madam. There's a order that had been issued by the APDCL for pay enhancement, madam.
It complied with by the respondent. Accordingly, the petitioner does not. Mr. D.
Chaudhary, madam.
Chaudhary, here, does not dispute the subject. Accordingly, taking into consideration subsequent the part, whatever the court does not.
Deeply honored. Thank you.
Order has been complied, my lord. Nothing survived in this matter.
None appears to the petitioner and will Mr.
A.D. On behalf A.D.
A.D.
on behalf of Mr. B. Sharma.
on behalf of Mr.
B. Sharma.
B. Sharma.
Yes.
Appearing for railways,
No, man. APCDCA.
APC, yeah. Some plantation. It- that- that is- that is the order. slightly, any document?
My lordship, the petitioner has intimated me, my lordship, that the order has been complied, my lord.
Do you have any communication, document, order to that effect? No.
No, with that regard,
What was the direction?
I will list of statements, my lord. Already there were 37 numbers of employees, my lord. We have a list also, my
What
lord.
was the direction? given by the-
To pay the pensionary benefits and other
pay the retirement benefit within a period
That
of
has
3
been
months,
released.
my that has been released.
Direction contained in the order dated in the direct. Is the retired. Which your name?
P.S. Raja, my lordship. P.S. Raja.
Yes, correct.
much.
As per office, right? It's after 4 weeks. As per the order of court certain directed made by the other. However, the same is not likely. The order was passed. They go to 28, 2024. The last order of the court dated 28 by 2025 reflects that the correction in the name of the respondent of the file has not been made. The matter appears manifest because accordingly, the
I'm appearing for respondent number 1 to 4, lord.
it is one who
1, 2, 3, and 4, lord. Oblige. Okay, as per the office note dated 27/5/2025,
sorry. Yes.
as per office note, lordship, 27/5/2025, we have filed amended post title.
In terms of the direction contained in the your order, the
FLIP.
statement title is with five, matter be listed for admission.
Yes, lordship. Lord.
After week, parties may exchange meeting.
Lordship, we will file. And one more thing, Lordship, by the order dated 4/4/25, Lordship, notice upon SLRC, newly implemented respondent has been issued, Lord. Yes,
Did it come for admission?
yes, Lordship.
Eh, wait, 1 minute. Notice is served. It come for admission.
Lordship. Respond number 9. Okay, Lordship. Deeply obliged.
Yeah.
May it please your lordship. Lordship, this contempt petition was filed, lordship, alleging non-compliance of the order dated 24/11/2023, lordship. Thereafter, lordship, they have passed one speaking order, lordship, on 25/4/2025. We have challenged that, lordship, in another writ petition. This is, lordship, regarding the regularization of drug inspector.
Where is that? What is the direction of the court?
Lordship, page number 49, lordship. Paragraph number 17. Under such circumstances,
This is already done.
my lord,
This has been complied with.
yes, lordship. This has been complied with by an order dated 25/4/2025.
Which is under challenge.
Yes, lordship. Hearing concluded, lordship was pleased to reserve
So
the.
this we can close it.
Yes, lordship.
Sorry, counsel. I agree. Right? Okay. Taking it into consideration. Right?
Highly obliged.
As per the last order, we have taken steps, and later on the matter was listed on Lozima Court. And as per the order of Lozima Court, the steps has been completed, but the private respondent has not yet.
As per Lozima Court order dated 005/2025, notice has been served. After 2 weeks.
My lord, kindly, the petitioner will retire within 3 months. So kindly fix the date, my lord.
After 2 weeks. 20.
Obliged, ma'am.
For respondent 1, 2, and 3, my lord.
Matter be listed after 1.
Lordship,
Oh, 20.
28, 2025. Step of the respondent. This service on respondent are related. Copies taken. Yes. You are here.
What are reflected, Lordship?
You are appearing in this matter?
Yes, Lordship, on behalf of Mr. S. Datta. Lordship, we have filed the Manatnama on 25/2.
You are appearing for the sole respondent.
Yes, Lordship.
Pursuant to notice issued by the court, Mr. Appearance on behalf of respondent. You want to file some evidence?
Seek instruction, Lordship.
Type. Stop.
Obliged, Lordship.
With respect to respondent number 3, service has not been completed. The office note dated 25.
Respondent number 3. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25. 25.
Lordship. Executive Officer Silchar Municipal.
Your response is the service is not complete.
Not complete.
You want to take that step.
Lordship.
Take that step. If I read it,
Miss B. Devi Lordship for respondent number 1 and 2.
maybe is the let the step be completed within 1 week from today.
Lordship.
And to be listed after 3 months.
Oblique.
In this matter, we are filing our affidavit in the course of the day today. Lordship may fix the matter.
Mr. Ganguly, Mr. by the after you want to file, you might be willing to file a reply. How much time do you require?
Has not been served yet. 4 weeks.
Yeah, we'll serve
Be
it.
listed after 3 weeks.
So the date may be fixed as an interim order, staying the disciplinary
You
proceeding.
file your affidavit.
We'll file it.
You file it.
So Lordship will,
How you say you have not filed, they will file a reply and you want a date fixed.
can I pray, my lord, let it come immediately after the July
Yes, it
vacation?
will come, but you file it.
Yes, sir, I'll be filing it today. My lord. That may be.
Matter be listed immediately after the reopening of the court. After that, on a date.
Lordship, there is an interim.
The petitioners may file their reply affidavit, the affidavit which proposes to file a interim orders, if any, we continue. Yes.
My lord, they are supposed to file reply
Affidavit.
Lordship, in fact, Lordship, my friend has filed 2 writ petitions, similar writ petition, Lordship. In one writ petition, Lordship, writ petition number 42918, I have filed my affidavit. That he has withdrawn, Lordship. Now I have to file in this case, Lordship. So similar affidavit I have to file in this case also.
So how much time did
2 weeks, Lord, 2 weeks.
we? The nearby court. Sir, after 2 weeks. It will be after 3 weeks because you will file a reply. You might like to file a reply
maybe, my 3 weeks.
after 3 weeks.
All right, Lord.
Lordship, apologies at the outset. Since the matter came up on 2023, file has been misplaced in our chamber. I pray for some time to reconstruct it.
Yeah.
And that we are also supposed to file some improvement petition. I'm not in touch with the client, my lord, so time may be granted. In the meantime, I'll send some registered post.
Counsel for the petitioner take liberty to file for additional affidavit. Bring on record some document which the title hearing. Their mail is not only grateful, it's after 3 weeks. Represented by you reconstruct your brief in the meantime. You don't want the same excuse again. Both the matters are connected. You are filing in both.
Both.
And appears to the petitioner involved, Mr. What is it, infractor?
If it become infraction, sir, his matter was considered marriage. His only grievance is that His only grievance is that, my lord, his matter was not, case was not considered, my lord. DLC is considered, my lord, and since there was no vacancy, his name couldn't be recommended.
The recommendation was filed by the petitioner in the limited prayer that his case be considered for appointment any post of professional ground by respondent with the Mr. Hardboard appearing for respondent number
Respondent number 1, my lord.
1 and Mr. A. Pugan for 2. That is
Three,
the-
three also, 1 and 3, I believe.
for 1 and 3. Submit that the case of the petitioner was considered by the district level committee in its meeting held on 28/3/2018. What is the name of the petitioner here? So this is the earlier considered.
No, my lord will find page number 18. Page number 18, but there are the direction of this honorable court, my lord.
So that was considered.
Yes, thereafter it is considered, my lord. Meaning thereby you have
But,
complied,
but this not consideration is not challenged.
not challenge. This has to be now challenged. This is prior to that, my lord. My lord will find in synopsis,
Submit that it is
bottom part, my lord.
and so what is the finding of the department now?
Finding is that when
DLC is trying to accommodate. Who know what decision has been taken? And this is at 22.
22, my lord.
Yes.
My lord, once consideration has been given, my lord, there was no vacancy.
It has been considered, but not be appointed due to lack of vacancy. The DLC thereafter is trying to accommodate the petitioner with other claimants who had not been considered in accordance with the writ petition. It is seen that it is here. This court by filing WP number 5/4/17, which stated both of I was dated 28/8/17, whereby the district level committee was clarified to the commissioner in accordance with law within a period of 4 months. Person and petitioner's case was considered and it was rejected by the DFC as RMA. Thereafter, the petitioner replied. But you are now required to give updates as to what has happened here.
My lord, once the matter is considered, my lord,
I'm going by your instruction.
My lord.
Your instructions say that they are now trying to consider accommodate the petition. First it was rejected, and then they are trying to accommodate the petition. That is the instruction.
Then, my lord, I will also find. But after that notification, my lord, 18(9), no compulsion appointment, my lord. We are not going for any fresh, unless that OMA is challenged, my lord. That part is also there.
But then what happened to the coordinate bench order of writ petition pending to be considered? You consider her case.
No, my lord. That order specifically, my lord, states that it cannot be precedent, number one. Number two, only those cases pending and those who have challenged the notification. So this is prior to the notification, my lord. This is not under challenge. Only those cases are covered, my lord. Very specific, that order. Other,
Writ petitioner. They are keeping it next. In the absence, we don't want to
my lord.
dispose it of on.
No, my lord. I listen.
Unappealed.
Lord.
Unappealed to the petitioner on all levels. Respondent is
One.
after 1.
Deeply obliged.
May I please, your lordship? In both these matters, my lord, the affidavit from the health is required, my lord, for the execution of the matter.
I'm praying for 10 days time to file the affidavit, lordship.
MSD Bora Council, Study Council for Health, prays for further 10 days time. 2 weeks time, pray for the file the affidavit after hearing. Mr.
Yes, Rabhaman.
Yes, this after 2 weeks. You file your affidavit.
Yes, Lord.
Respondents are permitted to file their affidavit within the 2 weeks time granted.
Obliged.
My lord, I'm seeking a week's time to get instructions on this, my lord. There's a recommendation in the writ petition. We will seek instruction why the appointment
Yes,
has not.
Mr. Kolkar.
Lordship. He was recommended long back in 2023, but Lordship, others have been appointed, but this petitioner is not appointed. Will it take 1 week time fixing a date?
J. Kolita for the petitioner, Mr. Rai Bota for the respondent. Further 1 time. Completed instructions after 1 week.
Did we fix it?
20.
20.
24.
Obliged.
Basically, the issue here was that whether the person or the petitioner was getting the substantial allowance or not. That we have already stated in our affidavit that 75% substantial allowance is getting, and after that there is some proposal. On the last order process, lordship, we are required to show the evidence, basically the record, whether he is getting or not. On that, lordship, one updated instruction we have received, which state, lordship, with reference to the subject, I would honor to submit here it, the payment of record of Muhammad Saifuddin Ahmed, March 24 to November 24, the budget proposal with effect from July 23 to February 24 has been sent to the Commissioner PNRD Assam.
No, subsistence allowance apart, what is the status of the proceeding? Department proceed.
Oh, that part, Lordship, that's another issue. Lordship, that part, because in the affidavit, we have stated that department proceeding is even going on.
So, going on the, what is the status? None appears for the petitioner, not the case. The petitioner has been receiving the subsistence allowance.
Yes, yes.
And the department proceedings are also underway. Although he does not have the status, progress of the department. Represents the expectation.
So, Lordship, you have received so many instructions and paragraphs, comments, Lordship. Lordship, I need some time to go through all these paragraphs of papers, Lordship, and accordingly file the affidavit if necessary, Lordship.
Yes. It's the case forward. Completely. Give you 2 weeks.
Yeah, Lordship, no problem.
It's after 2 weeks.
No service.
Lordship, here, although we have written letters for instruction, Lordship, but I don't think we have received extra copies here, Lordship. Extra copy missing.
You not received extra copy.
Given, we can provide. Already is given, but we make.
It is not available, Lordship, in the file or letter.
Council, Government Council, and Mr. Sharma submit that pursuant to issues of notice, extra copy will not be furnished. Mr. Equally the council. Yeah, that is submit that extra copy will be furnished. Be there as it may, the council for petitioner will ensure service of extra copies. The government advocate will serve extra copies within 1 week. But if we missed it thereafter, we missed it after 2 weeks thereafter.
Please, your lordship. Lordship, may kindly be taken up after some time, lordship. My
Lordship, my
senior
lord, last order was that it was fixed on my lord at 35. On 35, my lord, that it could not be, my lord, taken place the hearing. In then next date is, my lord, only order on a 6/6, lord.
No, what date?
Earlier was 30, lordship, 05. The hearing date was appeal.
Before the department.
Lordship.
So what happened on 35?
31 it could not be taken place, lordship, due to some problem, my lord. So it was rescheduled on a 6/6.
We'll fix it after 6.
There are 12 number of cases.
Government advocate appearing for the revenue department submits that the last date fixed for hearing of the appeal was on departmental appeal was on 3005/2025. However, no order, no hearing took place, and the matter has now been fixed again on 6/6.
6/6.
Therefore, the matter being fixed again after. Fixed again. On 11th.
My lord, my name is
Mr.
Hussein for number 6.
A Hussein for respondent 6 and for 11. Respondents were supposed to file something.
Yes, written submissions, written arguments. We have submitted.
Yeah. Here. Lord, in this case, the petitioner challenged the precursor actions for induction into IAS. Initially, interim order was passed by the Honorable Court. Against that, my lord, stay vacating applications were filed. That stay vacation was rejected. Thereafter, appeal was filed before the division bench, saying that since matter relates to induction to all India services, due to availability of Central Administrative Tribunal, writ petition is not maintainable. The division bench has dismissed the writ petition, holding it to be maintainable. Against that order of the division bench, SLPs are pending before the Supreme Court. Not disposed of, my lord. The matter is likely to be taken up for final disposal immediately after summer vacation. So, Lordship, may I pray for fixing this matter in the first week of August?
Submitted by the there is a like
Not this has not been fixed, but court on the last occasion, the Honorable Court has said that it will be taken up for final disposal immediately after vacation.
Second week of August.
Not
whether HP and
mobilized.
Deeply obliged.
Commissioner, my hospital dismisses service due to non-appearance and his absence for long period. Therefore, I this petition for retirement benefit and discharge certificate. Affidavit shows that he has not entitled the retirement benefit except the insurance amount. He's received the insurance amount. This is that I am paid for direct respondents to issue discharge certificate, which can be used for his private job or any other purpose.
Who's for the respondent?
He's an army person.
TGC.
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 Only Mr. Bora was appeared.
Wait for the TGC. Appears for the other appears.
Matter is become infra as law.
What is the challenge here?
This is regarding non-selection of the petitioner lordship. It was the physical test conducted by the police lordship. We have filed our affidavit.
It appears that the
Deeply obliged, Lord.
May I please? That the petitioner is the first of the disease lordship. Disease was service as a tradesman in the army department lordship. So during the lifetime lordship, the petitioner was not divorced by her husband lordship. Now they are saying that she was divorced and the family function was paid to the second wife lordship. By saying that the petitioner has submitted the divorce of Kaji lordship, divorce petition of the Kaji lordship. Divorce given by the two Kaji lordship. But the petitioner has filed a representation in the year 2020 lordship. Lordship, can they come to page 17 lordship? Page 17 of my petition lordship. Yes, lordship. Get it lordship. There are two lordship. And Lordship, divorce certificate number nil dated 29 December 1994 issued by the Muslim Marriage Registrant Qazi in the district Qazi so and so Lordship, and court affidavit number nil so and so Lordship, personal application number nil Lordship. If the divorce certificate was issued by the competent authority Muslim Registrant Qazi Lordship, there should be certificate number Lordship, and it should be communicated to the petitioner Lordship as per the Sharia Lordship. But that the petitioner didn't acknowledge that he was divorced Lordship and illegally entered the name of the second wife Lordship.
Have you
So
challenged that?
have
you challenged that certificate?
I did not get it Lordship. So they have filed their reply Lordship, affidavit Lordship, but in this affidavit also they did not annex it Lordship, merely saying that the petitioner has divorced his first wife Lordship in the year 1988.
Where is that?
Lordship may call for this Lordship, certificate Lordship, divorce certificate. They knowing this Lordship, petitioner can challenge it Lordship. They did not annex it Lordship.
Why don't you go and approach that authority who has issued the certificate, find out whether it is certificate was issued?
So the petitioner went there again and again filed the representation before the respondent authorities, but they did not give it.
Which respondent authority?
Respondent that means
there is a certificate.
Army Departmental certificate. Give direction.
The affidavit which is filed, these enclosures are not here.
Lordship, may I allow to file the additional affidavit to bring it on record or not?
I do affidavit to file.
Just one page affidavit. Lordship.
Huh?
Just one page affidavit.
There is no reference also that you are making any enclosure.
Lordship.
What will be the purpose of bringing it here?
Yes, Lordship.
What is the purpose?
Lordship, the petitioner she has no knowledge that her husband was divorced Lordship. Therefore,
We are not.
she was
We are not. This is not a knowledge in sharing institute.
she was maintained by her husband during the lifetime
You have
Lordship.
no knowledge.
Now,
Go and gather your knowledge. We are here to decide whether you have a right, whether you are entitled to the writ or not. We are not here to facilitate information coming from the department.
Lordship, you dispose by giving the district corresponding authorities to give you pensionary benefits as
No, on what basis? You are already divorced.
Yes,
If you
Lordship.
want
Thank
to
you.
challenge it,
without knowing the Lordship how he will challenge it Lordship. So Lordship,
if you
humble submission Lordship that
how from where you gather information is for you as a
Yes, Lordship.
counsel to advise your
when
client.
I'm getting the information from
Lordship,
their department Lordship, when
divorce-
the death of the petitioner Lordship,
Your divorce will be conducted by which authority?
by Muslim registered and Qazi Lordship.
Why don't you go and approach and find out whether any divorce deed is executed?
She,
It will be there in the record.
she went there Lordship, but they did not supply them.
Where have you stated that? Where have you made the Muslim marriage registrar as a party
Divorce,
for not furnishing you these documents?
Lordship, divorce took place 1988, Lordship, 18 July 1988, Your Lordship. She has communicated in 2020, 19 August, Your Lordship.
If the divorce took place in the year
Where have you
1988,
said that you have
in the
approached
year,
registrar?
pardon, Lordship,
Where have you stated in your petition that you have approached the registrar? And they declined to give you the relevant certificate.
para 9, page 9 Lordship,
Page 9.
page 9 Lordship, para 9 Lordship.
Where? Where?
Para 9 Lordship. The petitioner begs to state that she is legally married first wife of the deceased employee and she was never divorced by her husband. And such Lordship Center.
We are asking you a question. Did you approach the registrar of the marriages and ask for a copy. And your claim is that it has been denied. Have you stated that in the petition?
As per my knowledge, Lordship, petitioner was went there for copy of the certificate, Lordship, but they denied it.
That is the writ petition. As you say that where submitted third counsel, the petitioner claims to be the first wife or late Abdul Rahman Orlosco, who was employed the tradesman based under the respondent number 5, named the accounting officer, 57 counted ORD unit with petitioner submits that out of the marriage between late Abdul Razak Orlosco, sorry, late Adijur Rahman Orlosco, a daughter was born, daughter and a son was born. Son, however, expired. The daughter is alive and at the time of filing the writ petition and details are high school living certificate. The because of marital discord between the petitioner and the petitioner petitioner's petitioner lived with her parents, although there was no official divorce between the petitioner and parents. Her late husband passed away on 9/8/2020 while he was in birth. The petitioner thereafter filed representation to the authorities concerned. The he was informed that her name struck off from the next of kin status. Basis of the document stated to have submitted by her late husband, showing her have been divorced. The petitioner before the court submits the counsel for the petitioner submits that she was never served with any divorce deed or order, and to the best of her knowledge, no divorce was that taken place. Although she had approached the authorities time and again, the respondent authority did not furnish with any copy of the divorce deed or order. Under such circumstances, he being the first wife, he being the first wife of the of late Swenson with a title pensionary benefit over and above the claim of the second wife whose private respondent number 7. Since her claims were not redressed, he has approached this court by the strong pursuant to the file an affidavit stating that the divorce took place. Divorce between her and her late husband based on 18 July 1988 before the Muslim marriage registrar. From this information was available with the respondent authority on an affidavit submitted by late Adijur Rahman Orlosco dated 31 December 1994. The petitioner counsel for the petitioner therefore remains the respondent be directed to release her pensionary benefits as she is the first wife. So, thereafter, the CBC
to 6, your lordship. 1 to 6.
Hearing for respondent 1 to 6. Submits that in terms of the information available as per the record, the employee, the husband of the late husband of the employed husband filed the affidavit stating that the petitioner was divorced by a divorcee. Accordingly, whatever pensionary benefits are there has been released to the other DLAs, including private respondent 7. Where is your daughter now?
With her mother, lordship.
Which mother?
Mother, lordship. Along with petitioner, lordship.
Petitioner. How old is the daughter?
Daughter is major, lordship.
Major.
Major, lordship.
Married.
Not married.
Married.
Married. Married, but she is divorced, lordship now. She is divorced.
Yeah. If he will be made available that there is a dispute. There is a factual dispute raised with regard to the status of the marital petitioner with state court. While the petition claims she still married, was married or lost for the time of his right, but the respondent authority on the basis of documents available in the record submitted an affidavit was filed by his Lord Court during his tenure, enclosing the deed of divorce with the petitioner. The such circumstance, the only question decided is whether under such circumstances the claim of the petitioner for the grant of pensionary benefits cannot be decided unless the question of the issue of divorce with late Lord decide. So, in order to decide this issue, the marriage certificate, the divorce has to be essayed by the petitioner before an appropriate forum, and on such specific finding by the said forum, further proceeding may be proceeded with by the insofar as the claim of pensionary benefit for the daughter is concerned, the same may be examined by the department in terms of the pensionary rules. See whether the claim of the daughter in respect of the pensionary benefit can also be granted. Be that as it may, since the private respondent is not represented, although the private respondent court is of the view that the law regarding the grant of pension, grant and the share of pension between the various legal areas is settled by a full bench of this court in Republic. The full bench of this court had following direct. In terms of that, the authority will examine the claim of the petitioner and thereafter pass the order. Then with the judgment of this court and the respondent number 7 will also ensure that the pensionary benefit received the authorities will consider and dispose of the matter in terms of the court data. Yes, this court take up this. Without the status of your marriage, we cannot proceed further. We can't even direct the private respondent to give you a share of the pension because she will deny your marriage. Yes.
Lordship, if I may. Lordship, the counsel for the petitioner, Lordship, Mr. Somo has just been appointed as a member of the board of directors to the respondent bank, Lordship. So, Lordship may kindly grant some time so that appropriate measures can be taken.
It is submitted that the counsel who had appeared earlier represented the respondent petitioner earlier has been appointed as the board of directors, member of the board of directors. But back commits that he cannot represent the petitioner and wait for 3 weeks' time to make alternative arrangements. Let's go and put the respondent.
And for the bank, respondent bank, as thus.
Just after 4 weeks.
Grateful, Lordship.
The Lordship. Lordship, in this case, the petitioner applied for the applied in the recruitment of assistant deputy controller, civil defense and civil defense demonstrator, operator, mainly for the post of civil defense. And thereafter, my lord, he received the admit card also. He was qualified in the written exam also. But on the date of practical examination, my lord, he was not allowed to enter. And verbally, it was said that you do not. It was informed to him that he is not an ordinary resident of Assam. And thereafter, his admit card was also torn off and thrown. And he approached the specific department. He filed and he approached them via email also, but he did not receive any response. And thereafter, we approached this honorable court. Now, my lord, in this case, affidavit in opposition has been filed, my lord. We would like to file our reply to the same.
For the petitioner submits praise for 3 weeks' time, file reply affidavit. Yeah. He wanted it. It's after 3 weeks.
Much obliged.
May I please, your Lordship? Lordship, I have received the instruction. Lordship will kindly grant me 2 weeks' time to find the affidavit by the finance department.
Similar prayer was made last occasion also. That is pending since 2022, my lord.
Made that prayer in April.
Yes, my lord, the instruction was not complete because we are not being supplied with the, my lord, appropriate
Now is it
notification.
complete?
Yes, complete.
Mr. R. Borpuzari, counsel for the finance.
Finance, my lord.
Submits that he has received complete instruction and would like to file affidavit on record. Mr.
HL Ashram.
Mr.
HL Ashram.
HL of prayer made in all of the this after a week, the state respondents.
Date may be fixed, my lord, since it is.
Then let it come in July. Matter be listed in the month of July on 18 July.
Most obliged.
I'm so obliged.
Right, please, your lordship. In this case, I was supposed to bring on record development, subsequent development. I pray for another two weeks time, madam.
Mr. H. Ramu, for the petitioner, brings for further 2 weeks time. File the additional affidavit.
And Chaudhary, my lord.
The Indian court.
The respondent.
Any objections?
No, my lord.
List after 2 weeks.
Published.
Yes.
It is a complete, this is in regards to appointment of an arbitrator. The basic grievance is for certain waiving of certain LDs that was imposed on us. Contract initially granted. I was given the LOA was granted. Could not.
There are some disputes, you issued a notice.
Yes, there was a dispute in regards to an LD. A notice was issued. They said we want to mediate and some conciliation needed to be done. That failed. Subsequently, another notice issued. So now we are before your lordship for appointment of. We've already proposed the name of one arbitrator now. I think it's.
So we also ready, Lordship, we are proposing Honorable Justice J.R. Midha, we are proposing. Where is, sorry, you are opposing to the proposal. Where is the
Proposing a
opposition?
leave.
Where is the arbitration?
Yes, please. Page 42. Fourteen point one, my lord.
What is the claim? What is the amount? Claim amount?
Yes, my lord. Would your lordship be kind enough to see the notice, my lord?
Below or above 5 crore?
Yes, this is beyond 5 crores.
Beyond 5.
Yes, my lord. It's around, in Indian currency, it comes to around 15 crores or so.
So where is your notice?
Yes. That's at page 108, my lord. The first notice. Then subsequently, another notice was issued on at page 114.
108.
Yes, 108 and 109.
And what about you?
Yes, Lordship, we have responded to this Lordship by letter dated 14/11, Lordship, this number.
So you both of you have suggested your arbitrator.
Yes. I think both of them will then have to appoint an umpire, whoever is required, because it's 3 arbitration until unless your lordship decide for one.
Why 11-6?
No, they have not appointed, only I appointed. I had given my preference. They have now, I think they have only given it now.
For you to decide, tell us, you agree? We close this, if you disagree, that we appoint on our own.
I don't know whose name is proposing.
Share the name.
Whose name are you proposing?
Yes, Chairman.
Delhi High. Delhi High.
We'll share it, Lordship.
I think I have a problem on that.
We take it up on Friday, you decide and come back.
Yes.
Better be right. Or on Monday.
Friday would be.
Friday.
If it is not inconvenience.
Friday.
Friday. Wait.
It's not Friday.
Hello.
Your lordship relates to discharge of
Trading complete. My lord, trading is complete. My lord will fix it for final disposal immediately.
What is the matter?
Matter, your lordship, 2 home guards, your lordship, were engaged by the authorities, your lordship. They were discharged. The word used so far as there is concerned is discharge, your lordship. And after that, they have not been re-engaged, and being aggrieved by that, they have come before this honorable court. In the affidavit, they said they have not discharged them, your lordship. Now, issue is, your lordship, under the home guard rules, there is 2 provisions. That is, one is discharge, one is dismissal, your lordship. Now, once it is discharge mean, your lordship, for a particular period they were engaged, your lordship. On completion of that period, they discharge, then they come back to barrack, and then, your lordship, then they were again called for duty. That's the discharge. Here, your lordship, they have not been called for duty again, your lordship. Therefore, it has taken the form of, your lordship, dismissal. So this is precisely the case, your lordship. That's what we are.
What is your stand, Mr. Dhor?
They, your lordship, say.
My lord, if we have filed a affidavit, there are It is stated, my lord, that home guards, my lord, they are appointed for a particular project or particular, my lord, skill. So, my lord, they are usually, my lord, always attached to some police station or an SP in a district. They depute, my lord, when they require. And when their job is over, my lord, this is not a permanent job, my lord. That is what the thing is. And even I have seen somewhere they have sought in the prayer for regularization.
That is not, your lordship. There is no provision, no. I am not pressing that. There cannot be regularization.
What do you say about the judgment of the apex court that was
That says, your lordship, regularization is not
permissible.
That prayer is, your lordship, ought not to have made, your lordship, in this topic.
Then?
The rest, your lordship, I am not seeking a regularization. Okay, discharge, and when.
No, but that is again the prerogative of the department. They want your services, you will get.
No, that they have not come up with the plea that more particularly our services has not been required. That is not their plea, your lordship. That's in the affidavit. Had they said that here our service is not required, then matter may have took a different. But they generally they say that yes, that it is.
When was the last time you were given?
Your lordship, that is, we were discharged, your lordship. Your lordship will get it at page 19, your lordship. 30/11/2023.
Thereafter, no duty.
No duty, your lordship. And in fact, your lordship, rule says, your lordship, there is a provision for discharge as well as then dismissal. Dismissal they can, your lordship, on certain conditions. Now, your lordship, home guard is a ultimately.
They have stated categorically that you are not discharged or released.
That is what, your lordship. They have said this, your lordship. Had I not been discharged, they should have, your lordship, called us to duty again, your lordship. But your lordship will kindly see. That is what I have pointed out to your lordship. That is the prerogative.
You are supposing you were. Where were you allotted duty?
Your lordship in Nalbari, your lordship. Nalbari.
Where?
Your lordship, that is, your lordship will come to page 19, your lordship. Nalbari police station, your lordship. One is at Nalbari police station, one is at traffic branch Nalbari, one is Dhamdhama outpost. Now, point is, your lordship, they have specifically mentioned here that not discharged, your lordship. And in the affidavit, they are saying not discharged.
Page 90, chapter 4. The word used is discharge from deployment. Your affidavit says they are not discharged. What is the meaning of that?
My lord, that confusion I understand, my lord. So this is the affidavit. It comes from document number 4 and 9, not by the SP. Who has, my lord?
Get your affidavit.
That has to come.
Get your instruction. Yes. Who has released them? The page number.
SP, your lord. SP.
By how many criminal?
PV, your lord. And second one.
Guard. And where later here. The district of nobody. Subsequent. They were discharged. Employment. Discharged by the SP. Then SP. It's by the respondent authority say that they are not discharged or released from the home guard role However, they have not been allotted all for DP in the past 2 years.
Sure.
Whereas Mr. R. or on the other hand, hearing for the respondent referring to the affidavit filed by respondent 4 and 9, submit that the petitioners are not discharged or released from the home guard role of the district. However, on perusal of the pleadings available in court, in the order issued by the SP, lead and SP Nolbari, the petitioners are shown to be discharged from employment. As such, the government advocate is permitted 2 weeks further time to complete his instruction as to whether the petitioners are discharged or released from the guard
Sure.
role, or guard role, whether any such orders have been passed, their effect, and if not, whether the petitioners are still available for being deployed for duty. If they're still available for deployment for duty, then the reasons as to why petitioners have not been deployed for duty. All these instructions will be given to the court by next 8 weeks. Based after 3 weeks.
Sure.
The problem.
Your Lordship, I beg pardon, Lordship. I am standing before division bench, Lordship. Item number 32, Lordship. So, Lordship, can you be any Lordship, before rising, Lordship, any time I am available.
We had already passed some order.
I was in division bench.
It is 4 weeks. It will come after 4 weeks.
Any short date maybe can you be given?
Right, 3 weeks.
This matter is suspension, prolonged suspension, Lordship. So, Lordship, no departmental proceeding, no inquiry.
No, your matter is gone now. Don't argue now.
I admitted, Your Lord.
Your matter
But
is
Lordship,
gone.
I am in division
You
bench.
find out from the court master, and we'll see if we can take up the matter again at 2 p.m. Right? You
Your
find
Lord.
out from the court master.
Your Lord.
Don't interrupt proceedings like this. This is not
I
the
mean,
way to do it.
Yeah.
You may be before any bench, but this is the proceeding going on. You can't just interrupt.
I admitted,
proceedings
Your
like
Lord. Before division bench.
Your before division bench, school bench is not the concern of this court. You were not there when the matter was called up. Therefore, we had passed some order. You should wait before the court.
Taken up at 2 p.m. Your Lord. Your Lord.
Yes. Don't interrupt proceedings like that.
May I please, Your Lordship, my Lord?
Lawyers are expected to have some repeated mannerisms. Merely because you are entitled to appear before the court doesn't permit you to say anything and everything anytime. There is a proceeding. Follow it up.
May I please, Your Lordship?
Yeah.
Here in the instant case, my Lord, matter is relating to inter-se seniority between the petitioner and respondent number 4, my Lord. In the meantime, my Lord, respondent number 4 has already been retired, but his service was extended for the period of 1 year, my Lord. Last time, this honorable court has directed me, my Lord, to file an affidavit, my Lord. Accordingly, order dated 23/5/2025, my Lord. I filed the affidavit, my Lord, bringing these facts before this honorable court. My subject to my Lord, my learned friend may agree, my Lord. Now, respondent number 4, my Lord, as per notification of the government, he cannot claim, my Lord, to the next higher post, superintendent.
Right.
He has already retired, my Lord, and his service has been extended, my Lord. So, my Lord, as because he is not cannot claim, my Lord, the authority can, my Lord, authority can decide these things, my Lord, considering the notification I have annexed, my Lord, that Your Lordship kindly go to the petition filed on 27/5/2025. Filed by me, my Lord.
Petition.
Sorry, my Lord. Additional affidavit. Sorry, my Lord.
Twenty.
7/5/2025. Page number 180. That is the order, my Lord. In pursuance of government letter number so and so, letter 9/9/2000 GAD Assam, Sri Retired Horen Kumar Sharma, Senior Assistant Reception, Lok Seva Puraskar hereby extended 1 year of service, same to Senior Assistant. His service has been extended, he was retired, my lord. Now you also come to page 183, my lord. Of the office memorandum dated 9 December 2022, my lord.
Yeah.
This minister, this is the Government of India Ministry Personnel PG Pension Department. Here you also kindly come to the, my lord. Para 7, my lord.
Para?
7. Page 183.
Yeah.
While proposal for extension of service for higher post, if all found necessary to apply higher standard of efficiency service, whose appointment to the higher post are recommended approval appointment committee. The number of posts is bounded to very limited, and few persons should not be them for too long. No government servant who has extension of service after the prescribed date of retirement should be promoted to another post during the period of extension of service. Now he cannot be promoted to the next post to the superintendent. I am also going to retire on my lord. I think 31st July I am also going to retire, my lord. So considering this fact, they can take the decision, my lord. This notification and considering the fact.
This notification is a central government notification. Whether it is adopted by the state government or not, I don't know. I will have to open instruction regarding additional affidavit. In main case, we have filed affidavit. Whether he is retired or not, I have not received. I have filled
He is extended. Where is the question of not retired? He's been extended.
Extended.
No, my lord. This additional affidavit will notification. Whether he is eligible for promotion or not, I will have to open instruction. If the government
who is eligible? Who's
private respondent?
Private.
Yes. He says private respondent is retired in March 2025 and he's extended for 1 year for awardees. He got prize. So whether state government notification is there or not, whether the state government follow the central government notification, during the period of extension or re-employment, a person entitled for promotion also. To this point.
Yes. What is there to oppose? You are retired. You are retired. Yes or no? Yes. You're not retired or not. You're on extension. How can you claim for regular promotion? After you retire.
Let me have this.
What is
no, it's not this is
you are such an astute counsel for the department.
He's a awardee person, mother.
If he's there, whatever he can claim prior to retirement, he may be entitled.
That means the Monday, mother, I will obtain instruction whether he is actually entitled or not. If it is not entitled, matter end.
How can you give him that entitlement after his retirement?
So retirement will be extended. He continuously he is working because he is the awardee. This extension is on the basis of price.
Is not right. You are not questioning the extension. He is also not questioning. But whether you can consider him to be a member of the regular cabinet.
At least matter Monday, no problem. Because petitioner was told junior graduate in 2008. She suddenly after 60 years jumped. Oh, I have been chosen junior. Then she's claiming by filing this petition, I am a senior.
She did not come across Mr. Chaudhary for all these years.
That's why, my lord, Monday.
I am not arguing on merit, my lord. If I am arguing on merit, they have stated. We do not know how that this respondent number full name has come above my name, my lord. This is their stand, my lord.
Why the petitioner was sleeping over that time?
Yes, I am coming on all, not all that. Only thing is that.
Yes, at this point only.
At this point only.
Monday, my lord.
Monday.
Mr.
Chaudhary.
Obviously, but after April may not be, I don't know. But yes, yet, my lord, he has filed this.
Mr. NNP Chaudhary. Mr. D.K. Roy. He has put private responsibility. Mr. wait for the time will complete. It will the private as to whether the notification, where is the notification?
Yes, my lord. In additional affidavit, my lord, your lordship,
Whether the notification,
for reason 180, my lord.
you can write whether the claim of the private respondent for next time considered by the you of the OM
181.
9th of December 2000 is enclosed as the next one. The additional affidavit. This will be on Monday.
May I please, Your Lordship? I'm appearing on behalf of Mr. SCKL, my senior. We had to file a written submission, Your Lordship, but since he is suffering from high fever, Your Lordship may grant us short period of time to file this written submission.
But we'll have it after vacation. How much time do you want?
Week, Your Lordship.
One. Okay, then let's have it on 20. Mr. Bora?
My friend had actually said that the matter will come up on 9th because they are ready with that written arguments as such. Because after 9th, then the lordship, because otherwise
Let it be on 20. 20. Report by the company. Sorry, respondent. Mr. D. Bora.
we have filed a
D. Bora for the petition. For the review. For the respondent. Okay.
there is an interim order playing.
Interim order. We have already passed it until further order.
Until further. Highly applied.
I am on behalf of respondent, my lord. Receiver is not well, my lord. Please 2 weeks time, my lord.
Yes, any objection? The raise Islam for the keep rate for the right needed to be in this role. It's not like
Obviously.
Matter pertains to my lord, suspension of the petitioner, my lord, under Rule 6.2 of my lord, Assam Services Discipline and Admin Rule. My lord, it's an admitted position that my lord, within 90 days, my lord, review order was not reviewed, my lord. When my lord matter was listed before this honorable court, my lord, they before restarted, my lord. But actually had instructed to my lord get the office memorandum issued by the my lord Chief Secretary of Assam, my lord, sent to the my lord Ajay Kumar Chaudhary case, my lord. Okay, my lord, get the copy, my lord. May I?
yes, we have that.
Yes, my lord. The office memorandum says that after issuing of notice, my lord, within 6 months, the review should be done.
3 months, my lord.
But nevertheless, my lord, the review was done much later, my lord. I'll admit this. Almost after 9 months, the review was.
Minimum 3 months.
So you have violated your own office memorandum. You are supposed to first serve the charge sheet before expiry of 3 months.
Yes. Our sheet was served, my lord. The review was done much later.
When was the charge sheet served? Before expiry.
That, my lord, it was not served on me, my lord, till today, my lord. Only, my lord, on my lord, 11/4/2025, my lord, instruction was placed before this honorable court, my lord. And on that instruction, it was my lord, stated my lord, on 4/7/2024, my lord, review was done, my lord. Whereas, my lord, I was suspended, my lord, on 6/10/2023, my lord.
On
You were suspended on which date? Where is the order?
Page 27, my lord.
27.
Page 27.
27.
Page 27, my lord. 6/10/2023, my lord. Thereafter, my lord, I was allowed
When
to.
was the charge sheet submitted?
it was submitted in 6/11/23.
6/11?
23.
6/11.
Yes,
Not received.
Not serve on me, my lord.
Charge sheet?
So called
Memorandum of charges.
yes, the order that we had placed, my lord, earlier, there the copy of the review order, my lord, of 4/7/2024, my lord.
Yes, 4/7.
Yes. There, my lord, we'll see in second paragraph, departmental proceeding was initiated and so,
6/11.
yes,
Issued on 6/11.
My lord, review was done, my lord. As per instruction, my lord, 4/7/2024, my lord. But no memorandum of charge was served on me, my lord.
No. It says that department proceeding initiated, show cause notice issued. This is by way of an order. How is it that no show cause notice?
But my lord, as per direction, my lord, of the other statutory case, my lord, memorandum of charge has to be, my lord, served on me, my lord. Memorandum of charge.
No, you get your
Then,
order.
my lord, let them file a, my lord, affidavit, my lord.
Can you bring this on record?
we can bring this. I will ask.
If you have the right order, the respondent Mr. Order to submit on instruction that as per the order issued by the executive engineer of this order issued by the executive engineer dated 4/7/2024. Departmental proceedings were initiated and show cause was issued on 6/11/2023 of the petition, and she submitted a written reply on 29/11/2024. So the petitioner was suspended on
6/10/2023.
6/10/2023. The board have therefore submitted that it is within the period of 3 months after suspension that the memorandum of charges have been issued. And therefore, there is no violation of the procedure. The mandate of the memorandum dated 4th of February. Mr. Borua, on the other hand, submits that as per instructions received, no memorandum of charges have been furnished. The such circumstances we permit to bring on record relevant materials to show that relevant materials to show that department has initiated the department proceeding and served on the petitioner immediately after suspension within the period prescribed. List again. 2 weeks.
2 weeks.
Right.
Yeah. Yes, have you received anything?
No, my lord.
You have not received the written declaration?
My lord, my learned friend is over here, my lord.
Yes, Mr. Counsel, here.
We have appeared, we have contacted the arbitrator. They've said that they will instruct us, but as yet not done it. Was asked to submit before this court, Your Honor.
Yes. Where is that written instruction? Where is written declaration?
That is not there, Your
Have you received or not?
No.
There appears to be some communication gap between you and your local council.
My lord, in that case, my lord, I will serve once again the copy of the order to the learned arbitrator, my lord. My lord, may kindly keep posted for the next date.
We'll keep it next week. You complete your instructions, and if you receive the written declaration, furnish it before the court. We'll confirm the appointment.
My lord, my lord.
In terms of the earlier order dated 20, is submitted to the department. The parties have communicated the order of appointment to prospective, third and prospective arbitrators. That is clear. However, the written declaration of it received after for a week's time, 1 week.
My lord.
1 week's time. Period. We listed after 1 week.
Grateful, my lord.
After 1 week.
My lord.
Review of which order?
Lordship. Order by which the subsequent arbitrator was appointed, Lord, will find it page 10 Lord, of the review petition.
Page 10.
Page 10. I just place the background also.
Yes.
Earlier, late Colonel Manoranjan Goswami was appointed as an arbitrator. Now, the present arbitrator was the secretary of that arbitral tribunal, Lordship. When Colonel Manoranjan Goswami expired, thereafter they filed a petition and she was appointed. Of course, in the order, it is reflected that no objection has been raised from our side, Lordship. But the fact that he was already a secretary to the tribunal and she was appearing in one case against us, the very same department, Lordship, the very same division. So when after she was appointed, thereafter we filed this petition. Prior to that, Lordship, we filed a petition before her under section 12.5 for a declaration that was been rejected. Lordship will find that Lordship communication that.
Section 12. What declaration?
12.5 Lordship that is not connected with any. 12.1. That will Lordship will find at page 31 Lord. The paper book. Running page. 59 negative.
Then what reply?
Then she rejected it by her communication. Lord will find at page 34. She has not made any comment, only she has stated page 35, Lordship. May I read, Lordship? Further, it is pertinent to mention that the respondent has submitted a letter dated so-and-so, bringing some allegation against the arbitrator with respect to some comments made by the respondent. At present, I would like to make any comment on those allegations, but I would like to state that instead of doing this kind of activities, the respondent should be more focused on the case and try to submit all requisite documents in time before the arbitral tribunal and contest the case in best possible way. Also refrain from sending some documents though all means in communication. Any communication to her also would be sent to the claimant's vice. So what that objection we have raised that she has to make a declaration whether that was not done, Lordship.
Yes.
In view of that, Lordship, we are here, Lordship.
But that may not be ground because, my lord, this 1215 was amended in the year 2015 and that is not applicable as because the arbitration proceeding were commenced prior to 2015, my lord. Even the earlier arbitrator was appointed prior to coming effect of the amendment in the year 2015.
That is not.
First of all, my lord. My lord.
What is the question is the subsequent amendment. Subsequent amendment.
Yes, but my lord, section 21 of Arbitration Act speaks about when arbitration proceeding starts with. commencement of arbitral proceeding.
Review, as you know,
Lordship.
is very
Lordship.
within a short term.
Lordship, whether review will lie or not, I am relying upon two decisions, Lordship. That was on the record.
Lie or not is a different, but here is the question that you are now bringing these allegations against the arbitrator. Whether this is the matter for review
Lordship.
or for filing a proper application, seeking, raising objection.
De jure, that's Lordship section.
Secondly, my lord, this is not a ground of to be raised before this honorable court. The honorable Supreme Court has already, my lord, cleared the point, my lord.
May I just Lordship query, may I just section 14, Lordship. That de jure and de facto. That will come into in my respective submission, Lordship.
So you are objecting on 12.5.
12.5.
Come to the schedule. Where is that? Where are the 7 schedule?
Lordship. 7 schedule point number 1, Lordship, will come into my help, Lordship, because he said that the arbitrator is an employee, consultant, or advisor. That advisor is there, Lordship. So,
No. Advisor.
Legal advisor.
Business relationship with a party. So was she an advisor of the army?
No.
Then
She's the respondent, Lordship.
Respondent.
OP, yes. She's appearing in a case, Lordship.
Same respondent.
Same respondent, Lordship. I have the order, Lordship.
Why have you not given the disclosure?
Lord, that is arbitrator. Arbitrator will disclose. But my lord, this.
Why don't you submit first and then refer to your judgment?
This is the duty of the arbitrator. Arbitrator will.
What arbitrator will do? You, once an appointment is there under 12.5, you have to give a disclosure in writing. Read 12.5. What does 12.5 say? One. Sorry.
12.1.
12.1. This was inserted in 2016. When did the arbitration comment?
This part is not applicable because, my lord, the proceeding as per section 21 commenced when request for appointment of arbitrator is given.
Correct. Arbitrator was appointed.
Yes.
He abandoned the proceeding. Or what happened? He expired.
I know.
Then a new arbitrator is to be appointed.
New means he has substituted.
Substituted. So will you say the substituted arbitrator is not bound by 12.1?
Because, my lord, the proceeding starts by virtue of section 20.
Questioning about the proceeding.
And secondly, my lord, even if, my lord, this declaration is
what is your difficulty in giving a declaration? That is the question.
That I have to take, my lord, instruction.
Take your instruction.
My lord.
Give your declaration.
My lord.
Why are you unnecessarily elongating the matter? That comes before the hearing for the respondent. We have the instruction that's to by the arbitrator. That's not. It should be the declaration. Who has submitted the order? Meghalaya engineer.
Lord.
You have submitted.
Because she is appearing in that case against us for the petitioner.
And whether the declaration, if any, will also explain whether he has any handicap under section 12.5. 12.5. This after 4 weeks. 4 weeks.
Please, Your Lordship. Lordship, in this matter, I'm only challenging orders that have been passed by NHIDCL minutes on the ground that adverse stigmatic findings have been derived against me behind my back, my lord, based on allegations of insubordination and non-coordination. Without hearing my side of the story, they have passed stigmatic orders against me, violating my rights under Articles 14, 19, and 20. I'll quickly take my lord through the facts of the case.
Before the matter has been listed for hearing, it is not yet admitted. By order dated 9/2/2024. So we have raised the question of maintainability. That was kept open.
Let everything be taken up, my lord, today itself.
Tell us what happened. Right?
Well, fact is, NHIDCL, that is the state respondent, had engaged me through one of its agencies.
Engaged you as what?
As a contractual employment. I'm a lawyer by profession, young legal professional. That's my designation. I was working under their direct supervision and control.
In-house counsel.
As an in-house counsel, Milan, I was hired via their intermediary or an agency known as Pioneer. I was working under them, Milan, direct supervision and control. My assessment reports, everything were prepared by NHIDCL. Two assessments had taken. Initially, what happened, Milan, I had joined in the year 2020. In the year 2022, I had filed a complaint for harassment against the respondent number 4, Mr. Jha. So after my complaint was filed, investigations started against Mr. Jha. Subsequently, my performance was assessed by NHIDCL. They said my performance was of A grade quality. Subsequently, 6 months later, there was another assessment. Therein, they said that my performance is very good. So throughout, since the year 2020 till my date of termination, I have annexed all the reports. They have said that my performance was either A grade or very good in nature. So as far as my performance is concerned, they were always satisfied with my performance. It's there on record. Subsequently, what happened, Millet? This complaint that I had filed against Mr. Jha, that complaint is there, Millet, in this writ petition. The findings, the verdict was given by the Internal Complaints Committee of NHIDCL itself.
What complaint?
My complaint, Millet, is at page 30 of the writ petition, Millet, Annexure E. This is my complaint against respondent number 4. For verbal abuse and making derogatory comments on character and intellectual capacity at workplace via telephonic conversation. So subsequent to this complaint, my assessment took place, which are at page 27 as well as at page 28. They say that my performance is very good and my work is of A grade quality. This is post the filing of my complaint. In the meantime, subsequently, the verdict of the complaint committee is out, which is in their affidavit in opposition, which was never handed over to me. That's a different story altogether. Their affidavit, page 52, the verdict of the complaints committee is out. The relevant para is at page 56 of their affidavit in opposition. It states, ICC is of the view that the aforesaid complaint received from Ms. Jaya Sharma against Shri Ranjit Kumar Jha, that is respondent number 4, can be of the nature of misbehavior or indiscipline, which does not come within the purview of ICC. So there were findings of misbehavior or indiscipline against respondent number 4.
You filed an application for sexual harassment.
Sexual harassment. But the finding was, at best, it can be said that it is in the behavior, it is in the nature of misbehavior or indiscipline, but not sexual harassment. That is the finding of the internal committee at page 56 of their affidavit in opposition. Para 10, the final findings of the committee.
After this, my lord, what happens? Two orders are passed by NHIDCL. I'm only challenging those two orders, the state action, my lord, which is arbitrary. I'll point it out to my lord. Now, if my lord comes to page 34 of my writ petition.
Which order are you challenging?
One at page 34, my lord, and one at page 50 of the affidavit in opposition. If I can draw my lord's attention to the order at page 34. It states that my performance is unsatisfactory, so I should be replaced. So stigmatic adverse findings have been arrived at behind my back. Two principles of natural justice have been violated here. One is nemo judex in causa sua. How can a judge be? How can the judge have a personal interest in the matter? The same individual I complain against.
Order is passed by the same person.
Same person, Millet. It should be set aside. They're completely violating nemo judex in causa sua principle. And this finding that my performance is unsatisfactory has been taken behind my back. No show cause notice, nothing. And it's totally contrary to the records.
What is the other order?
The other order is at page 50, Millet.
50.
50 of the affidavit in opposition. I came to know about it for the first time after they filed their affidavit in opposition, against which I have given my rebuttal in my affidavit in reply as well. And this order, which is at page 50 of the affidavit in opposition, if I may draw my lord's attention, her performance, including the coordination with the headquarters NHIDCL legal division, is found to be unsatisfactory. This is another stigmatic finding, Melod, which has been arrived at behind my back without even issuing me a show cause notice. If my performance is so unsatisfactory, you should have at least handed me a show cause notice within this period of 6 months, my lord. Since my last appraisal report, till this particular order, no show cause, no memo, not a single deficiency was pointed out to me, not a single warning. I was not placed on any improvement plan. And suddenly, my lord, out of the blue, they hit me with this order.
Where is your appointment order?
My lord, I was appointed via their agency, that is Pioneer, which is at page 19, Mellon. The first page, Annexure A. I was appointed via their agency, which is Pioneer, which is at page 19 of the writ petition, Mellon. I'm only challenging these stigmatic findings, Mellon, that have been arrived at behind my back, nothing else. These adverse orders that have been passed behind my back. I'm not challenging my termination order, Mellon, because the final termination letter was issued by the private agency, which is anyways not amenable under 226. So even if I have any grievance against the private company, I should approach some other forum, not this honorable court. I am approaching this honorable court to only assail the actions of the state, that is NHIDCL, whereby they have violated both the limbs of natural justice, along with articles 14, 19, and 21, my lord. They have denied me of my livelihood without adhering to the procedure established by law.
No, but your appointment is by the Pioneer.
Absolutely, my lord. But, my lord, I have an agreement.
NHIDCL, have they issued any order accepting you as?
I was deployed there, my lord. In fact, I have.
So you are an employee of whom?
I have been engaged by Pioneer, and I'm working.
Who's paying your salary?
They are paying it. NHIDCL is paying it to the agency who sends it to me. So they are the principal employer under whose direct supervision and control I'm working. What? They have basically done something indirectly which they can't do directly.
Who's for Pioneer?
Pioneer, they are not represented today.
This is issued.
Pora was representing.
They've not even filed their wakalatnama. I'm not challenging. I have nothing to do with Pioneer, Millard. I'm only challenging these adverse orders passed by the state, stigmatic findings, which carry a stigma, Millard. Because the final termination order has anyways been passed by Pioneer. They are not coming under 226. This forum, Millard, I'm not pressing anything against Pioneer. I'm just challenging these two orders passed behind my back, my lord, by the state arbitrarily. My lord.
Your only ground, your ground is that it's being passed by the person against whom you have made the allegation.
Yes, my lord, that's nemo judex completely. And my lord, one more aspect that I would like to bring to your kind notice. My lord, I have an agreement between NHIDCL and similar private organizations like Pioneer. My lord, what NHIDCL does, it does not hire people directly. It always hires them via third party. So I have an agreement of NHIDCL with a similar outsourcing company known as TNM. If my lord peruses clause number 4.20, my lord, and 4.21. 21 is
all documents, whatever you have made on
because until and unless NHIDCL directs the private 4.21, my lord, if I may read out. 4.21, my lord, 21, clause number 21. Here, agency is Pioneer, the private company, my lord. The agency shall replace immediately any of its personnel who are found unacceptable to the client. Found as in there has to be findings of misconduct, negligence, or inefficiency by NHIDCL because of security risks, incompetence, conflict of interest. They've given all the grounds, and on the instructions of the client office, he shall be replaced. That means the concerned employee, contractual employee, shall be replaced. So unless there are direct instructions from NHIDCL to the private company, I will not be replaced. But there has to be findings to that effect by NHIDCL. Here, findings have been arrived at, stigmatic adverse findings have been arrived at, but behind my back, Millet, without giving me an opportunity of hearing. So in a way, Millet, it completely violates this clause as well, because this clause does not bar the principles of natural justice, or it does not say anywhere that no show cause notice will be furnished or no hearing should be given. So when it is not specifically barred, Millet, principles of natural justice are considered implicit, Millet, in the clause. Unless specifically excluded here, natural justice is not excluded. And Millet, I'm a 28.
Is there any formal agreement or anything between you and NHIDCL?
No, Millet. But Millet, the principle of law is very clear, Millet. Any state action that entails civil consequences.
You are engaged by the third party. The agreement is very clear that
They have actually cleverly bypassed the procedures established by law. Usually what you can't do directly, you can't do indirectly. What they can't do directly is terminate me without an inquiry. So to bypass the entire due process of law, they are using this particular agency as a conduit to do the needful, my lord. However, if my lord pierces the veil, which my lord has the power to do so, my lord would see how they are trying to take a benefit of a loophole, my lord. But every state action, my lord, that entails civil consequences.
Every state action is correct, but you have volunteered, you have decided to accept the service in this complicated
I agree, Millet,
manner.
but Millet, I can't be terminated unless and until NHIDCL presses it, Millet. They have pressed it. They have invoked their powers. Because of the invocation of their powers, I have suffered. Until and unless they invoke their powers, Pioneer would have never replaced me. So the direct cause of action initiates from NHIDCL, Millet. The entire list has been started by NHIDCL. Pioneer is just a mere conduit in it, Millet, and I'm the sufferer.
You are required to, your entire contract you have executed with Pioneer gives you the parameters of your engagement.
But Millet, Para 21 clearly, Millet,
So para 21 is
covers me as well, Millet.
No, it is not with you. Is it with you?
Yes, Millet. It actually, it's between the two of them, but it actually affects my rights, Millet. It says the agency shall replace immediately any of its personnel. When they say personal, that includes me.
Between who?
It's between NHIDCL, Millet, and the private agency. But it affects my rights, Millet.
You then
Well, my only humble plea is that
please get the contract between NHIDCL and this thing. Is that Pioneer?
Yes, we have.
You have? Is it a part of the pleading?
no, it's not part of the pleadings.
Bring it on record. Let us see what relationship.
Same clauses, Millet.
Bring it on record. On record. Since Pioneer is not there before the court, you get it from your record and bring it here. Let us see.
Millet, my only humble plea is that this stigmatic word should be removed, Millet. Nothing else, Millet.
Which stigmatic word?
Millet, stating that her performance, including
Page
the
number?
court in page 50, Millet,
50
of the affidavit in opposition. Well, because I'm a law student, Millet, my entire life is there in front of me. Every time I approach a prospective employer, they say that there is stigma. So it creates a negative impression on their minds, Millet.
Which one?
Page 50, Millet, second line, it says, her performance, including the coordination with the headquarters NHIDCL legal division, is found to be unsatisfactory. Millet, I just want this para to be expunged, Millet, because it's been arrived behind my back. And also, Millet, the entire order, which is at page.
Is that all you want?
Is that yes, Millet, and the entire setting aside of para.
We'll close it. That this shall not be.
That's it, Millet. That's what I only want, Millet. Make it a simpliciter order.
Concerned with that.
Simpliciter order. That's it, Millet. No stigma on my character, Millet, without hearing me. That is my only concern, Millet.
No, but we are not interfering with this.
Termination. No need, Millet, because it has anyways been passed by a private party, who's anyways not amenable to this honorable court. And Millet, the setting aside of the order at page 34, which has been issued by the same party against whom I had complained, Millet.
Yes, Mr.
R4, Ranjit Kumar Jha.
His only grievance is that this should not have a stigmatic effect.
That's it, Millet. Nothing else.
That to that extent, Millet, we have nothing to say. If your lordship, Millet, declares in that regard, Millet, that it will not be treated as a stigmatic in future course of employment, etc. Yeah.
No, just set it aside or let them withdraw it, Millet. If they withdraw it,
withdraw, Millet, then again, Millet.
You are making.
Fine, Millet. I'll stick to my stand.
No, you think about it.
Millet, I've had a word with my client. She only states that
either you see setting aside will require to get into the various
merits.
aspects. But
Millet,
if the only thing you require,
yes,
is that it should not carry a stigma, but the fact remains that this order will remain. We are not setting aside with this order.
Millet, let the orders remain. The only language that can be used is the agency. Millet, we can finish it today itself. We can only keep it like this, Millet. The agency is requested to withdraw Ms. Sharma with immediate effect. Full stop. With immediate effect. Full stop. Nothing.
We are not directing the agency to pass orders as per your wish. Why should we do that?
Millet was saying
whatever order is there. We were, because you made a submission, we can dispose of by saying that this order shall not be considered to be a stigmatic order for future employment.
Fine. Both the orders. That's it, Millet.
This order.
Millet, page one order at page 50 and one page. Millet, there are two orders, Millet.
Millet will kindly see the page 33. That is her termination order issued by the Pioneer. So if at all stigmatic Millet flavor is there, it is on this particular order. Page 33.
In order to come to finding that this particular order is not stigmatic, we have arrive at some finding to say that this order, why is it not stigmatic, or why should it not be considered?
But that order itself is not in Millet termination order. Termination order is at page 33.
Millet, I am challenging the foundation. I am challenging the foundation of my satisfaction.
Pioneer.
So if you are challenging the foundation, we'll address it. Therefore, we are asking him to bring that contract on record.
Fine. But as my learned senior said,
what is that page 33?
That is her termination letter issued by Pioneer.
Where is the formal letter?
No formal letter, my lord, only a mail, simpliciter mail by Pioneer. I was never issued any formal letter by by Pioneer. After this is issued on the same date, my lord, 19/1/2024, the day Mr. Jha shot his letter to Pioneer. So the entire list starts from NHIDCL's letters dated 17/1 and 19/1.
This the internal committee report came sometime in August 2023. Then, my lord, the officer above this Jha, he found that
You get the report of the record of the internal committee proceeding.
yeah,
Well, there's one
proceeding is
aspect.
there.
Hmm?
Proceeding for the final determination minute has been under annexed.
Well, at page 44.
We want to see the
Well, at page
the
44.
proceeding.
Let him bring the records, my lord. If there are allegations of misconduct,
See whether
let them bring the records.
We bring it.
It is an internal committee and
Bring it.
Well, at page 44, para 7.
Yeah.
the page 52, madam, the
Para-
recommendation of the
Page 44, para 7. This is the affidavit in opposition filed by NHIDCL, my lord. 1, 2, 3, 4, 5, 6. Sixth line, my lord, para 7. It is further submitted that Shri Ranjit Kumar Jha, respondent number 4, was holding a managerial position and has no authority to take decision regarding the employment or disengagement. This is their own admission, my lord. In spite of their affidavit in opposition, how can then Mr. Jha could have disengaged me by
Well,
this
this-
order?
This has flown from the letter of the general manager dated 17/1.
This is their affidavit, my lord.
Therefore, well, it is not that, madam.
This paragraph 7 has to be read with paragraph page 34 of my writ petition, my lord. Para 7 of the affidavit in opposition has to be read with page 34 of my writ petition. The order passed by the same Ranjit Kumar Jha, who has got no power to disengage me, according to NHIDCL. Their own admission.
He was employed under whom? Under which department?
NHIDCL, my lord, legal department.
That's the legal department.
I'm a lawyer, my lord.
So who is the who looks after the legal department?
My lord, my senior, I have my reporting officer.
gentleman.
My reporting
Gentleman.
officer.
The gentleman with whom you had this issue,
Yes.
is he connected with the legal department?
Well, he is related with the accounts department, administration and accounts department. This is the same individual I filed a complaint against, and who has passed this order. And according to NHIDCL, he does not have the power to disengage anyone.
Then, Mr. Oike, what do you make out of this statement?
This order has to go as
Page 17 is here. Page 15. Page 15. Letter dated 17/1. This has been issued by General Manager P with the approval of the Executive Director P, who is the has authority in the regional office.
You get the relevant record. It's not clear who has taken a decision. The dispute was with regard to general manager administration. He has written some letter. He has written a letter here saying that his services are not suitable. He has written some letter. Isn't it?
But that is 19, 19 letter, page 34.
He has written a letter saying that he has written it to the pioneer.
Pioneer.
Now it is not authorized.
He did not, madam, this is consequential to the page 50.
How can this be consequential to page 50? How can this be consequential?
17/1 comes before 19/1.
Yes, madam. Sequential to 17, I said it has to be after the 17. Communication kind of.
17-1-24.
Yes.
And this is 19-1-24.
Yes.
Now, if the gentleman is not connected with administration or anything, what business does he have to write them to take her away? How you are saying that this general manager personnel at page 50 has written a letter.
Right.
Is it not good enough? Should it be followed by another person from another department?
He doesn't have the authority. Ranjit Jha doesn't have the authority.
Well,
He
this
is
is just a communication, my lord. Even then, my lord, I'll take a, my lord, the instruction from them.
these are
Under what
orders to
this
the
letter has to be written.
these are orders that I'm
You
challenging.
get your instructions that we don't think something is wrong here. You get the reports, we'll examine it.
Right.
What is this that you're tossing around like this? There's a specific averment that this gentleman is not even concerned. So why is he writing letter?
My lord, paragraph 7, my lord, he cannot take a decision.
That's right. Then what action have you taken against this man who has written a letter to your agency saying that he is not suitable?
Well, he is not, my lord, this
Where are
page 19, my lord, nothing has been said, my lord.
Page number 34.
Yes, my lord, page number 34.
34 has to be read with para 7 of page 44 of NHIDCL's affidavit, wherein NHIDCL has
Why is he
admitted.
requesting? What business has he got?
My lord, as my lord, I have been instructed, is the consequential order. Even then, I'll complete my lord, the instruction in writing.
What consequential orders are necessary?
Of the 17. It was in my lord, intimation.
Intimation? That letter.
I'll come with it.
Sir,
Yes. Monday. That will be listed on Monday again. I think the
Monday,
I'll
have little.
So he has to obtain clear instructions.
Along with the records, Mellet, the entire records of the proceedings against me.
That City Council will also keep the relevant records ready for perusal of the court.
Can it be my lord on 12, my lord, or out of this 9,
Tuesday? Or we can do it Friday. Sorry, this Friday.
Let it be on 17th.
17th.
Right.